just give us a moment to set up our computers? The team have been working on them over lunch, and we have to reopen the papers. Thank you.
Thank you, my Lord. Two things before I draw the threads together on issue one. First, in response to a question from my Lord, Lord Hamlin, I indicated that there was an in-tank bill charter form, an in-tank charter form. There is no in-tank charter form. On the BIMCO website, they say that there is no form. There are instead various standard forms of tanker charter party adopted in the trade, as the tank buoy or BP buoy or whatever. So I do apologise for that error. Second, I need to deal with just one counter-argument raised by my learned friends at paragraph 27, page 99 of the written case. The owner places reliance on 3 cases in support of the narrow proposition that an argument that liability on a charterer to pay insurance premiums is sufficient to found a code has been rejected in 3 war risk cases. That is not an argument being advanced by cargo interests. Cargo interests are not suggesting that the mere fact that charterers were liable to pay the additional premium is sufficient to found a code. Accordingly, I'm not proposing to address those 3 cases now. I will deal with them in reply if I need to. But drawing the threads together then on issue 1, in the Evier, the House of Lords held that the war risk clause in the Charter Party, clause 21, which both gave the ship owners an absolute veto upon employment that would bring the vessel within a zone made dangerous by identified war risks, and entitled the ship owners, should they choose nevertheless to proceed, to take out extra insurance specifically against such a risk at charterer's expense, amounted to a comprehensive insurance-based code under which the owners and their insurers were to bear all risks of unsafety arising from the dangers identified. And we say, on a fair reading of the war risks regime in the Evier Charter, all elements of clause 21 that struck Lord Roskill as being of significance are also present in the war risks regime in the instant charter, if anything, as I've said, more comprehensive and sophisticated. And so we say the reasoning of Lord Roskill applies equally to the present case, and accordingly we invite your Lordships and your Ladyship to answer issue 1, like the Tribunal, like Sir Nigel Tier, in the affirmative, yes, on the proper interpretation of the Charter, and in the particular the war risks clauses. There was an implicit understanding that the owners were precluded from claiming against the charterers in respect of losses arising out of risks for which the initial insurance had been obtained pursuant to those clauses. Having shown why, I move to issue 2, why in our submission the Charter contains an implicit understanding. I now turn to address the question whether the bills of lading contain the same or similar implicit understanding. And it may be helpful if I were to begin by identifying the battle lines as I see them. In essence, the owners advance just 3 arguments. The first is at paragraph 70 of their written case, page 115. The argument is that the process of incorporation involves the mechanical transposition of express terms from one document to another, leaving behind implied terms or understandings. And for this reason, the owners assert the assumed implicit understanding in the Charter does not survive the mechanical process. And on this issue, the owners seek to support the conclusion of the Court of Appeal. The second argument is to be found at paragraph 73 of the written case, page 116. It is that whilst some of the operative parts of the war risks clauses were incorporated into the bills of lading, the clauses which obliged the party, the charterers, to pay additional insurance premia were not. On this issue, the owners seek to overturn the unanimous conclusions of the tribunal, the learned judge, and the Court of Appeal. The third argument may be found at paragraph 93 of the written case, page 135, and is that the word charterers, where it appears in the premium payment provisions incorporated in the bills of lading, should not be manipulated to the bill of lading holders. That's the manipulation issue. The third argument is premised on the owners being unable to persuade this court that the tribunal, the learned judge, and the Court of Appeal all came to the wrong conclusion. On the second argument, it is also premised on the assumption that the issue raised by the third argument, namely manipulation, is relevant. The cargo interest's primary case, as you will have seen, is that it is not. On the issue raised by the third argument, manipulation, the owners seek to uphold the conclusion of the Court of Appeal upholding Sir Nigel Tier, who had overturned the decision of the tribunal. So those are the arguments advanced by the owners. As regards the cargo interests case, so that the direction of travel is apparent, I will first state the case in summary. I will then expand the summary into a series of 8 propositions, and I will then in greater detail seek to make good 2 of those propositions, 7 and 8, which are controversial, referencing the authorities as necessary. Let me begin with the summary. Once it is accepted that the war risks clauses were incorporated into the bills of lading, then on the true interpretation of the bills of lading, there was an implicit understanding that the owners would look to their insurers for indemnity.
I wonder if you could take it a bit more slowly. Could you start again, please?
Yes, certainly. Once it is accepted that the war risks clauses were incorporated into the bills of lading, then on the true interpretation of the bills of lading, there was an implicit understanding that the owners would look to their insurances for indemnity in respect of losses arising out of risks for which additional insurance had been obtained pursuant to the war risk clauses.
Thank you.
That's a summary. The stepping stones to the conclusion can be stated in a series of propositions. First proposition is uncontroversial. The issue concerns the construction of the bills of lading. The second proposition is equally uncontroversial. The terms of the bills of lading are to be determined in accordance with the general principles of the law of contract. The third proposition ought not to be controversial. Short-form bills of lading depend on the incorporated charter for their detailed terms. The fourth proposition is that short-form bills of lading facilitate international trade, serving as a negotiable contract of carriage on terms substantially the same as the incorporated charter, and thereby promoting certainty. The fifth proposition is also uncontroversial. The bills of lading in this case use wide words of incorporation. Indeed, it is hard to conceive of wider words of incorporation. The sixth proposition is also uncontroversial. It is to the terms of the Charter dated the 20th of September 2010, to which the words of incorporation in the bills of lading are directed. That's common ground. The parties to the bills of lading positively intended to incorporate the provisions of this Charter. It was not an empty gesture. The parties to the bills of lading did not intend to incorporate nothing. The seventh proposition ought also to be uncontroversial because it was the unanimous view of the tribunal, the judge, and the Court of Appeal. The war risks clauses in the Charter, excluding the first and second paragraphs of the Gulf of Aden clause, were incorporated into the bills of lading. My Lord, Lord Hamlin asked for a detailed response in relation to those parts which are incorporated and those which are not, and we will attend to that overnight and provide that in writing. I'm sorry that we haven't been able to do it over the short adjournment. The war risks clauses in the Charter were incorporated into the Bill of Lading. This was because they are relevant to the contract of carriage in that they relate directly to the shipment, carriage, and discharge of the cargo, and to the payment of freight. The term most usually used...
Discharge of cargo and to the...
Payment of freight. The term usually used to describe such terms is that they are germane. The owners challenge this proposition in part, what I've identified as their second argument. It is the owner's case that the sentences imposing upon the charterers the obligation to pay the additional insurance premium are not incorporated. And I'll come to address that specifically. The eighth proposition is the most controversial. We submit it follows from the previous propositions that the bills of lading, on their proper interpretation, directly incorporated the implicit understanding in the war risks clauses in the Charter. And that understanding was that the owners would look first and solely to their additional insurances in the event they suffered losses or expenses covered by those additional insurances.
Well, given our earlier discussion, or the earlier discussion with Lord Legate, the implicit understanding is simply, it follows from the words of the Bill of Lading properly interpreted, that there was a contractual term that the owners were confined to their insurance. That's what it comes to, is it not? Does it not?
Correct.
It's not an incorporation of anything, it's just you say that that's
what it means.
That's what it means when it's set in the Bill of Lading contract. Is that right?
Precisely. The incorporation is setting it into the Bill of Lading context,
But it still has it actually has to mean something different for you, because in the context of the charter party, it's an agreement between the charterers and the owners.
Yes.
And you say that there's a similar agreement in the contract between the cargo owners and the ship owners.
Correct. Short form bills, certainty of provisions, terms incorporated, and the same regime to apply. And the consequence was that the owners were precluded from claiming against the holders of the bills of lading in respect of losses or expenses covered by the additional insurances. It's commercially unlikely, we submit, that the parties to the bill of lading intended merely to give owners the benefits of the regime, the rights and liberties and free insurance cover bestowed, one side of the bargain, free of any burdens, the insurance code, the other side of the bargain.
And were the cargo interests paying the premiums on your case, or not?
There are no findings that they did. The premiums were paid by the charterers.
Yeah, but I mean obligation, not what actually happened. Is it your case that it was a term of the bill of lading contracts that the cargo owners would pay the premium, the owners' war risks premiums?
Our primary case is that it's unnecessary to go that far, because so far as owners were concerned, what they were interested in was the other cargo interests, charterers and cargo interests, putting them into one pot, had paid for that benefit. That's our primary case, and therefore you can have a situation where A agrees to pay B, not only for its own benefit, but also on behalf of C.
Yes, so you're not saying that there was an obligation on the cargo owners to pay. What you're saying is the charterers paid for their own benefit and also the benefit of the cargo owners.
Correct.
That's the case. Yeah.
Correct.
Thank you.
But is that a matter of the construction of the charter party before you get to incorporation in the bills, or is that dependent on incorporating the charter party terms into the bills? So in other words, if you just look at the charter party, do you say the effect, proper meaning of the charter party is that owner hereby agrees not to pursue either the charterers or cargo owners, or indeed anyone else, for any of these expenses, and will look solely to the insurance fund?
That is what we're saying. We're saying that he's agreed an insurance code.
Yes.
In return
this will be my sole remedy. I, the owner, am covenanting that this will be my sole remedy.
Correct.
Nobody else will have any liability in respect of the relevant insured expenses.
Correct. Just as in the Evier, just as in the Ocean Victory.
Well, in the Evier, though, it's only a two-party case.
In Evier, it's only a two-party case. Correct. Correct. No, absolutely.
But you still, in order for the bills of lading holders to have the benefit of that, do you still have to show that those clauses were incorporated into the bills of lading? Do you accept that you also have to show that, as well as that, looking at the charter party, that was the agreement of the charterer with the ship owner?
Yes.
Because C, in your A and B, agreed to confer a benefit on C. In order for C to be able to enforce that, they have to have some privity to that contract. Isn't that how they get that, by incorporating the clauses into the bills of lading?
Correct. And in answer to the question as to I gave the answer to, which is our primary case, is the payment of premiums on behalf for the benefit of all of those on the other side, as it were, not the carrier, but those for whom the goods were being carried. Our alternative case is that if it's necessary, and the arbitrators concluded that it wasn't, that it would be appropriate to manipulate the language in order to replace charterers with the bill of lading holders. On that alternative case, there would be a direct contractual obligation on the part of the bill of lading holder to pay the premium.
To impose on the holder of the bill of lading the obligation to pay.
Correct. That's the extent of the manipulation case is only relevant in that context.
And the exact manipulation is the bill of lading holder, is it?
Correct, for charterers. I think we've set it out in our case, and if I've given the wrong language, I'll be corrected. But I'll come to manipulation anyway later, and I'll make certain that I am clear on that. But I think we say the bill of lading holders where the words the charterers appear.
I'm just wondering if there's an alternative way you may put your case, because the way I put it to you, and I think you agreed with it, was that if you just look at the charter party, seek to construe the charter party on its own, the effect of the charter party is that the owners have disclaimed, if you like, all possible claims against anyone except the insurers. I mean, that's quite an exorbitant reading, perhaps it might be said, of the charter party. But is there another way that you say that once you incorporate the war risks clauses into the bill of lading, and you then construe the bill of lading with those clauses in it, the effect is that the owners will not claim against the cargo owners, irrespective of whether the cargo owners are liable to pay the premium? Is that an alternative way you put your case, or not?
Certainly. I mean,
so that sounds as if there are three possible ways in which you put it. Is that right?
It does. I think that in relation to the first, I don't think we would submit it's not as exorbitant as it might initially sound, because the only people that one can have in mind in that context are either the charterers personally, or those who will be interested in the marine adventure, namely the cargo interests. And in our submission, that is a factor which the tribunal influenced the tribunal a great deal, because in their view they said the people who are really interested in whether or not there's piratical seizure are the cargo interests. And those are the people that the owners and charterers would have had well in mind when agreeing to the regime to which they agreed.
It seems to be a big step beyond the EVIA, because even if it's not sufficient, it's an important part of the reasoning that you rely on, that the charterers are paying the insurance in return for they're bearing that cost in return for getting the benefit of shedding a liability. But your case is that they're paying the cost in return for somebody else shedding a liability.
Well, it very often is the case that some third party will pay the liability, or some related company will pay the liability. And in our submission, it's not such a big step as a consequence. What is important is what is the nature of the bargain, and the bargain is the insurance code applies, and an essential feature of that is the insurance premia are paid not by us, the owners, but are paid by the charterers or on behalf of the cargo interests. And we say that's not such a big step at all. And indeed we say when one brings into play also the significance of a short-form bill of lading, everyone's intending that the charter terms are going to become part of that contract, it makes it all the more likely that insurance regime which is agreed between the charterers is going to have a real meaningful effect. Because as between the owners and the charterers, it's not going to have a great deal of effect. The people that are going to be directly affected are the cargo interests. So I was coming next to the cargo interests contend that the conclusion can be reached on these two alternative bases. My Lord Richards has suggested a third, and I don't suggest to the contrary. The first and the second are without the need to manipulate the incorporated terms. What has now become the third requires the manipulation of the additional premium payment term, and I'll put that manipulation argument to the side for the moment. The appellant's primary case is, as I said, that we can get there without manipulation. Let me then seek to address propositions 7 and 8, which are I submit, the controversial ones, although the 7th ought not to be, because each of the 3 tribunals below agree. The proposition is that the war risks clauses in the Charter, excluding the first and second, were incorporated into Charter. Sorry, let me start again. Can I invite you to have page 447 in front of you, the war risks clauses. Sorry, did I say?
I don't think you mean 447.
I think it's 47.
474, perhaps?
474. Sorry.
474, sorry. Sorry, I said 447.
Bear with me one moment. 477.
477.
477. My note has gone wrong. And the other important clauses at 508 to 510. The argument being advanced by the owners is extremely narrow. The owners concede, for this purpose, that the war risks clauses relate largely to matters concerning the safe carriage and delivery of the cargo, should one or more of the specified war risks occur. They acknowledge that they can take the benefit to be derived from the war risks clauses, but it's only the premium payment provisions which they contend do not survive incorporation.
So there are too many theys there. So
This is the owners.
owners say that the cargo interest can take the benefit of the clauses, but not the premium payment. What you're saying?
They say, correct, they say that these clauses are for the most part germane, but when you come to the premium payment provisions, the last paragraph of the Gulf of Aden clause and the first paragraph of the war risks clause, they say don't survive incorporation.
Yes, but I think Lady Rose's question, when you said they can take the benefit, you were talking about the cargo owners. Am I wrong about that? Have I misunderstood you? You said that the owners concede that the war risk clause, they acknowledge that they can take the benefit. Who was they?
Well, the owners can take the benefit of the war risks provisions as against the bill of lading holders.
Yes. Mm-hmm. Oh, I see what you mean. Yes.
It's only so
they can take in a question with the cargo owners. They can take the benefit of this clause.
It's a plums in the duff.
I see. Thank you.
Is what we're saying.
So the charters can take the benefit of these clauses as against the cargo interest.
But
The ship owners can.
No.
The charterers don't have a claim against the cargo interests.
Can you just say your sentence again, but put in which parties you're talking about rather than them?
That was the point I think Lady Rose was asking initially, and I've tried to repeat.
I'll repeat the two sentences.
Yes.
The owners concede that the war risks clauses relate largely to matters concerning the safe carriage and delivery of the cargo, should one or more of the specified risks occur.
Yeah.
The owners acknowledge that they can take the benefit.
Well, who's they? That's what we're trying to get at.
The owners acknowledge that the owners can.
The owners,
I'm so sorry.
The owners can take the
rather
benefit.
odd to say they acknowledge that they can have a
owners.
benefit, but it's agreed that the ship owners can take the benefit of the clauses.
Correct. I apologise for my choice of phrase.
As against who? Against the cargo
Lading
interest.
holders. The owners.
So the lading holders can't complain if the charterers, if the ship owners, sorry, exercise their liberties under the war risk clause, for example.
Correct. So in that regard, they're claiming the benefits of the incorporation of Clause 39, and it's only the premium payment provisions which the owners contend do not survive incorporation.
But I understood you to say earlier that you agree that the first two paragraphs of the Gulf of Aden clause are not incorporated. Is that, did I hear that correctly?
The first is the demurrage one. Because of the Miramar, it's been held that those are not germane in this
Right.
context.
I mean, earlier you said excluding Gulf of Aden clause paragraphs 1 and 2 when you summarised your submission 7.
I'm sorry.
So I took you to be saying that it was common ground that paragraphs 1 and 2 of the 3 paragraphs of the Gulf of Aden clause are not incorporated. And the dispute is actually all about paragraph 3.
The dispute is about paragraph 3 in the first paragraph of the war risks clause.
Yes.
Yes.
Was that correct to hear that you do not allege incorporation of paragraphs 1 and 2 of the Gulf of Aden clause?
We don't allege incorporation of 1. We do allege incorporation of 2, but without, again, the time demurrage element.
Yeah. Part of 2.
Correct. Because that is being ruled to be not germane.
Tribunal concluded that neither paragraph was incorporated, is that right?
If I can come back to you on that so that I don't get it wrong.
Well, I'm just looking at the judge's understanding of the tribunal's conclusion at page 155. He only turned it up as paragraph 29. I don't think that's limited to demurrage factors.
That's paragraph 29 of the judge's judgment.
Yes, my understanding of the tribunal's conclusion.
Well, let me check
Yes, check.
in the award whether that's right.
Well, you're saying paragraph 1 and paragraph 2 insofar as it relates to time, is that it?
Correct.
So the additional costs of a protection team and protective measures, would you say that that is included in the bill of lading and that the bills of lading holders are liable for that? That also is manipulated, if need be, in the same way as the insurance premium?
If it's manipulated, then yes, they're liable for them. If it's not manipulated, then they're purchased on their behalf. Our response is that the war risks clauses in the Charter Party are interwoven and must be read both together and as part of the whole contract, subject to, of course, aspects which are clearly inapplicable. In resolving issues of incorporation, it's inappropriate to focus on a particular term to the exclusion of all others. Related terms draw their meaning and effect from each other, and related terms must be read and interpreted together. And the fundamental flaw in the owner's second argument, which I'm dealing with, which has to date been rejected unanimously, is that it fails to read the war risks clauses as a package.
I'm not sure how you square that with picking out bits of paragraph 2 of the Gulf of Aden clause and not other bits. I mean, that's not reading it as a package. It's a very selective reading of the clauses.
It is reading it as a package, but putting a line through those parts which are clearly inapplicable. But the point that I'm seeking to come to is that in order to get the benefits which the owners obtain from these provisions, they've got to take the burden, which is the cost being paid by the charterers and the consequences of that being paid. And so if one turns to clause 39, it is the rights and liberties given to the owners by clause 39.
This is page?
Sorry, that's page 508 and 510.
508.
Yes. The most pertinent provisions for present purposes are on 509. On any view, clause 39 directly concerns the carriage of the cargo, whether or not loading is completed, whether or not the cargo is carried to destination by a direct or circuitous route, even whether the cargo is discharged at the expected port. Clause 39 gives the owner, as we've seen, an unqualified right to refuse to accept orders for the vessel to go or to continue to go on a voyage which will subject the vessel to any of the dangers to which the clause refers, and gives the owner wide liberties to comply with the directions of third parties. By way of example, pursuant to clause 39(3), the owners may not be required to proceed or continue on a voyage where it appears that the vessel, her cargo or personnel may be exposed to the war risks as defined. And if it should so appear, there are liberties open to them. Nominate, ask for another safe port, discharge where they choose if charterers fail to nominate a different port. And by way of further example, in 39(4), if at any stage of the voyage it appears that the vessel, etc., may be exposed to war risks, and there is another longer route, owners may give notice that this route should be taken. And the temporal scope of clauses 39(2), 39(3), 39(4) are defined by reference to the loading and carriage of the cargo. And clause 39(6), as we've seen, anything done or not, this is 510, anything done or not done in compliance with the clause shall not be a deviation. And given the consequences of a deviation for owners, this is a provision of fundamental importance to them.
But if this is incorporated into the bills of lading, this is, you wouldn't manipulate charterers in this iterative process of naming the port. You wouldn't replace that with bills of lading holders. The bills of lading holders are stuck with whichever port the charterer nominates if this process is triggered.
Our primary case is that you don't need to manipulate any of these provisions. So the answer is yes. You don't need to replace charterers with bill of lading holders. And the additional war risks clause then links in directly to this. If the owners choose not to avail themselves of their clause 39 rights and liberties and instead take out insurance protection against the risks associated with trading to excluded areas, the additional premiums are to be for charterer's account and are to be payable together with freight. The additional premiums are akin to freight in that they increase the cost of the voyage. And the Gulf of Aden clause also links in directly Again, if the owners choose not to avail themselves of their Clause 39 rights and liberties and proceed through the Gulf of Aden, the clause allocates the risk of delay and extra cost. It also repeats that any additional insurance premium in respect of both property damage and liability shall be for charterer's account. And although the latter two clauses impose caps, the owners will no doubt take the caps into account in coming to a decision whether or not to rely on the liberties under Clause 39. And the purpose of the exercise that I've embarked upon has been to show that you can't read each of these clauses or parts of them in isolation. They're a package that must be read together, and I hear the observation made by my Lord Legate in response to that. We acknowledge that, but we say that there are certain parts of it which are simply inapplicable. But unless you read the clauses together, you can't make sense of them. And that accords with the general approach to interpretation, which requires that a contract is construed as a whole and not clause by clause. So in short, the excursus has been designed to show that the clauses are germane in the context of a bill of lading context.
Well, you say they're incorporated, but clauses 39, 9.2, 3, 4 have a number of references to charterers.
Yes.
Charterers are to do, and notice has been given to charterers and expenses to be borne by charterers. Well, what effect do you say those have when incorporated into the bill of lading? Is it still referring to charterers?
Yes.
It is? Okay. Not bill of lading holders?
No.
Okay.
No. Unless the process of manipulation is required, which is our alternative case, and we say it's not, you don't manipulate those terms.
But you can't manipulate this so that the master has to work out who the bills of lading holders are and get telex or email them all and say, what port would you like me to go to? Then we may all come back with conflicting suggestions. So that bit must always remain the charterer.
Yes, well, I can see the force of the point. Commonly used war risk regimes would be undermined if charterers and bills of lading incorporating the charters were governed by different war risk regimes. If, as against his charterers, a ship owner could exercise the regime's unqualified rights to refuse to accept orders for the vessel to go or to continue to go on any voyage which will subject the vessel to any of the dangers to which the clause refers, or make use of the wide liberties to comply with the directions of third parties, and yet be left bound to perform the same voyage as carrier under the relevant bills of lading, because the war regime was held not to have been incorporated, it would result in inconsistency and uncertainty and an uncommercial outcome. And as I said, the owner's suggestion that the war risks clauses are not germane is a point only made in relation to the payment provisions in two of the clauses. And we say there is no justification for that approach. If you're looking at the clauses, you need to look at them in totality, insofar as they are applicable in a bill of lading context. And we say, once it is accepted that the war risks clauses are a package, then that particular argument falls away. The owners challenged the reasoning of Lord Justice Mayles that the premium payment provisions were directly relevant to the carriage and discharge of the cargo. So they challenge the Court of Appeal on that. With respect, we submit that the challenge is hollow. The parties agreed to a voyage via Suez, which would naturally involve passing through the Gulf of Aden. The parties also agreed a package of all risks clauses which provided important protections if faced with a danger to ship and crew. The agreement to the route was always subject to Clause 39 rights and liberties. If the master or the owners chose to exercise those rights and liberties, the agreed route would be superseded or varied, as might the destination. If the owner's master chose not to exercise their Clause 39 rights to refuse to transit the Gulf of Aden if the master or owners chose not to exercise their Clause 39 rights to refuse to transit the Gulf of Aden, additional war risks and kidnap ransom insurance would be procured at the expense of the charterers so that the vessel could pass through the Gulf of Aden. The ship owner's decision to proceed through the Gulf of Aden and not to exercise the liberty to deviate around the Cape or discharge elsewhere, for example at Jeddah, was conditional on and inextricably linked with the availability of insurance and the charterer's agreement to pay the premium. And so it follows, we say, that the premium payment provisions were directly relevant to the carriage and discharge of the cargo. Which takes me to the eighth proposition. By way of a reminder, the eighth proposition is that the bills of lading, on their proper interpretation, directly incorporated the implicit understanding generated by the war risks clauses in the Charter. Although in general Charter Party terms may not have precisely the same meaning in the Bill of Lading context as that to which they had in their original Charter Party context, the reasonable objective contracting party, by the act of incorporation, will expect the incorporated terms to have in the host contract the meaning they were intended to have and did have standing alone as outside terms. This will be the expectation of the contracting parties, even though they may not always realise that expectation. If the expectation of the reasonable objective contracting party is not to be realised, it must be because there is some aspect of the Bill of Lading which requires that the incorporated terms be given a different meaning or purpose in that different context. The judgments of Sir Nigel and the Court of Appeal in our submission result in a disconnect between the applicable regime under the Charter and the applicable regime in the Bills of Lading, designed to pick up and render transferable the regime under the Charter. The disconnect is that the Charter will be under no liability to the owner in respect of losses sustained by the owner, which are covered by the additional insurances, but the Bill of Lading holder will be. That produces a result which is uncommercial and may even be thought to be remarkable. Three reasons have been put forward by the courts as to why this eighth proposition is unsound, although the owners have only adopted the first on this appeal. The first is the Court of Appeal, page 145, paragraph 46. The Court of Appeal doubted
Which page, sorry?
Page 145,
145, paragraph
46.
46, thank you.
The Court of Appeal doubted whether the words of incorporation, although sufficiently wide to encompass significant parts of the war risks and Gulf of Aden clauses in the Charter, were sufficiently wide to encompass implied terms arising out of them. And this is the point adopted by the owners, and it's developed by them at paragraph 70 and following of their written case. Second, the Court of Appeal concluded that the implicit understanding had not been incorporated into the bills of lading, paragraph 58, page 147, because there are no clear words to rebut the presumption that owners did not intend to abandon their right to contribution from the cargo owners in general average, and any implicit understanding is not so clear that we can be confident that it was what the parties intended, not least where the Charter was not necessarily paying the whole of the additional premium which would be necessary to obtain the cover required. Now, as I say, this is not a point run in these terms by the owners. The owners run a related but separate point, which is issue 6. That general average is in a category of its own. But the issue 6 point is different because it is premised on the existence of a preclusion in the bills of lading, opening words of the 6th issue. But at the moment we're considering the prior question, whether the preclusion is incorporated into the bills of lading.
I find this still an unhelpful way of phrasing it. I know it's how it was in the Court of Appeal, but the question is what is the correct interpretation of the clause sitting in the bill of lading? It's not incorporating some implied understanding from somewhere else. It's just saying what is the effect of the clause such as to affect the cargo owners or isn't it?
Correct.
I mean, I know we've been around this before, but...
Yeah, well, precisely, and in our submission, and it means that I can cut out things I was going to be saying in a moment, it's precisely the reason why Lord Justice Longmore said what he did in the Court of Appeal in the Ocean Victory, which is that the Gilbert Ash analysis doesn't arise because once looking at once looking at interpretation of the contract, and once you have got to the point where you accept that the parties have agreed an insurance code, specific words to exclude that outcome are not required.
Why is that, then? I mean, you get there by saying that there is an insurance code, but that's the end result. You've got to invert it, haven't you? And say, well, if we're to conclude there is an insurance code, do there need to be clear words excluding liability or abandonment of remedies?
Yes. Both Sir Nigel Tier in the Ocean Victory and Lord Clark in the Ocean Victory adopted that analysis.
Right.
And the majority in the Ocean Victory said that that was not the correct approach to adopt. You must look at what the parties have agreed, and you mustn't come with any presupposition that they should write an exclusion in red or focus specifically on it. What you're looking at is the question of interpretation of the contract.
Right, so you say the Ocean Victory stands as authority for saying that in this respect the Gilbert Ash statement is inapplicable.
No, I'm going too far if I'm saying that.
All right.
I do apologise. The Gilbert-Ash principle is relevant to the analysis, but it's only one factor that one takes into account.
I see.
And if, having looked at the agreement reached between the parties, at an iterative stage of the process of interpretation, one concludes that the parties have agreed to an insurance code. In those circumstances, the fact that there isn't some Gilbert-Ash warning, as it were, doesn't matter. You don't have to go the extra mile and say, and by the way, the consequences of this are that the following long list of liabilities are excluded, because you would have to go through a long list. It's in this context, obviously only one arises, but you would need to have a long list.
So for this purpose, we're assuming that all references to charterers means charterers. Is that correct?
Yes.
Yes.
So the fact that charterers are paying our insurance premiums, along with the other factors you rely on, inexorably means that we are, even though we haven't said so expressly, giving up our right to contribution in general average from bill of lading holders.
When the charter party terms are incorporated into the bill of lading, it has that consequence, because if it were not the case, it would result in a divergence between the regime in the charter with the regime in the bill of lading. And indeed, the consequences would be to create a very significant inconsistency.
Well, there'd only be a divergence of regime if, in the context of the charter party, it's not only the charterers who are getting the benefit of having their liabilities relieved in return for paying the premium, but other people as well, the bill of lading holders. And the EVIA doesn't take you that far.
It doesn't take you that far, but in the context of where you go further and you have to look at a bill of lading as well, the owners and the charterers will have had well in mind that the people for whose primary benefit this code is being agreed is for the cargo interests. They're the ones who are going to be most, if not exclusively, affected by kidnap and ransom risks in the Gulf of Aden. The third reason put forward by the courts as to why the eighth proposition is unsound was that by the learned judge on page 166, paragraph 111, but I wasn't going to go to that because it's not a point that's raised or arises on this appeal. Can I then...
Can you just help me, sorry, just as background commercial context, typically on a voyage charter like this, what is the sort of arrangement between the voyage charter and the shippers? How is it working commercially?
In this case, the tribunal didn't make a finding of fact, but they assumed, based on what they've been told, that the cargo interests, that the charterers were the chartering arm of the cargo interests.
Right, and that's a typical sort of situation.
Correct.
Yeah.
Yes. And so the chartering arm will go out and get tonnage to carry the goods from A to B, St. Petersburg to Singapore, and the shipper is an entity in Russia, but the contract of sale, no doubt, again, we don't have the evidence, but probably an FOB sale in these circumstances because they've arranged the carriage. Consignee becomes interested in the goods on loading, and then is the person who pays the freight and who gets delivery of the cargo at destination. In this case, puts up the GA bond in order to obtain delivery of the cargo at destination.
But the goods may have been sold on many times and not have remained with the charterer's cargo arm.
The goods may be sold on by the bill of lading holder, correct?
Yeah, I think so.
But the context in which the carriage will have been arranged will have been initially by those related parties.
Does that affect the construction of either the charter party or the bills of lading? I mean, it doesn't seem to be something that any stress has been laid on.
No, it certainly doesn't affect it at all, no.
I don't see how it could. I mean, if the bill of lading is a negotiable instrument, it seems to be quite difficult to say that the fact that there was a link between the charterers and the initial bill of lading holders is relevant to the interpretation of the bill.
Although I think it has featured a bit in generally one of the authorities that you've referred us to, but I would have thought that would be right. Can I just clarify one point, if I may? On the payment of freight, again, I asked you about this morning, but under the charter party, the charterer is liable to pay freight to the owner. Does the charterer, or do the cargo owners pay the freight to the owner?
Invariably, the cargo interests pay
the freight. And that is split between the cargo owners, by reference to the volume of, in this case, oil being transported.
By reference to the amount paid by each of, in this case it was only one bill of lading, one party that was the holder of all six, but if they were separate,
yes,
then it would be the sum total of the payments made by all six.
And how is it divided between the six?
How is it divided between the
six?
six?
Per ton shipped, wasn't it? Correct,
per ton shipped. It's a freight rate is per metric ton. Each bill of lading has a number of metric tons.
So you're saying that what happens is, although the charterer is liable to pay the freight to the ship owner under the charter party, the cargo owners in fact make that payment, and that discharges the liability of the charterer.
That is the way in which it works in practice. The owner still has a right against the charterer, but if he's been paid, obviously he can't, there's nothing to enforce.
Yeah.
And if he's not paid, because the bill of lading holder goes insolvent or whatever, the owner still has the right of recourse against the charterer.
But that's expressly agreed in the bill of lading. Freight.
Correct. Correct.
It may not ultimately matter, but I haven't understood. Perhaps you could produce a textbook or something overnight, your explanation of why the charterers have an interest in general average. Because you said something to do with freight, but I would have thought aren't the owners paid the freight? They have that interest.
I will. Yes, let me. I will refer you. I mean, if you look at the general average adjustment in this case, you'll see that it involves charterers as well.
All right.
But then,
I don't want to take your time. I was just, but perhaps you could just produce a reference tomorrow or something to back it up.
A short reference to. I'm sure it's in the textbook on general average,
yeah,
of which you've got an extract, and I can get you the reference overnight. So the first point is implication, and the point has been expressed clearly and succinctly by my Lord Justice Lord Legate, and in essence that is our position in relation to it. But let me just quickly address it, if I may. The Court of Appeal, paragraph 46, as I said, doubted whether the words of incorporation were sufficiently wide to encompass implied terms arising out of them. We say that's a surprising conclusion, made all the more surprising by the fact that the point wasn't even argued in the Court of Appeal. But the doubt is misplaced for 5 reasons. First, as a matter of ordinary language, the word terms in the incorporating provisions includes both express and implied terms.
But you're not relying on implied terms, it's relevant.
We're not, but one of the primary reasons for finding against us was because it was said that what is an understanding or an implication cannot survive incorporation. All you've got is...
But I took your answer to this to be to say that this is all missing the target, because what we're saying is, as the Court of Appeal said, the words get incorporated, and your case is that when you construe the words in this context, they have the effect that the only recourse is against insurance.
Yes.
So none of this is germane, if I can use that word.
No, well, let me... I was just seeking to address the point that the Court of Appeal was seeking to make.
So you were going to make 5 reasons anyway.
Yes.
And can you repeat your first?
The second is that there's no reason in principle why a distinction should be drawn between express terms and implied terms. Third, drawing a distinction between express and implied terms ignores the commercial purpose of short-form bills of lading and undermines the purpose of incorporation, which is consistency. Fourth, it produces an odd result. Implied terms arising out of express terms are left behind on incorporation in this analysis. This is not consistent with ordinary principles of construction. And fifth, it's a process expressly deprecated by Lord Justice Cairns in the Annafield, and I'll just give the reference. It's page 736, paragraph 170.
Speak up, please. 736.
Paragraph 187A. The owners, in this case, contend that the incorporation process involves the, I quote, mechanical transposition of terms from one document to another, close quotes. That process was the process for which Anthony Evans QC, as he then was, unsuccessfully contended in the Annafield and it's dealt with. The process must be applied intelligently and not mechanically. The modern approach is the symphonic unitary exercise. The owners in this context place reliance on 3 cases, the Varenna, the Federal Bulker and the Saboti, but with respect, that reliance is misplaced. Those cases were concerned with a different point, namely whether it's permissible to look at the intentions of the parties to the Charter reflected in the unincorporated terms. So I won't deal with those now. I will in reply if I need to.
Isn't the process that you incorporate such of the express terms of the Charter Party as are germane into the Bill of Lading, and then, in that context, decide either what they mean as a matter of construction or decide that it is necessary to imply a term? I mean, I don't really see that you transpose from the Charter Party an implied term that is appropriate or necessary in the Charter Party into the Bill of Lading. The Bill of Lading is a standalone contract, but with the incorporated terms. Isn't it at that stage you ask the question?
It is. I think that I
mean, that may be behind what the Court of Appeal was saying here.
So since you don't rely on an implied term anyway at any stage, all this seems to be a rather waste of time.
But it is relevant to the...
I think the gloss that we would put onto that is, I agree entirely with that analysis. The gloss I would put onto it is that if a suite of provisions is incorporated into the Bill of Lading, and if that suite of provisions has an accepted understanding within it, a meaning attributed to it, then that is carried with it into the Bill of Lading.
it's not really an implied term, it's a consequence of the express terms.
Yes.
Correct.
You express it in a positive way, which is that in the charter party, the ship owner agrees that they will look, as you put it, first and solely to the insurance fund. And if that's what they agree, then it necessarily means that they're not going to look for any other fund. It's not really an implied term, it's the opposite of the express term, or a necessary consequence of the express term, and that's what's, I think that's what you're getting at when you say it's not really an implied term, it's just the reverse of the express term.
Correct. It's the interpretation put on the express terms, yes. The implicit understanding. It's the language of the word implicit understanding which creates the confusion. And I said it's the code, the agreement on the insurance code is perhaps a better way of describing it. Let me then move on to the paragraph 58 of the judgment, page 147. The second point, no clear words to rebut presumption. In our submission, there are two reasons why this conclusion is incorrect. And the first is, if I can invite you, please, to go to page 996. This is the judgment of the Court of Appeal in the Ocean Victory. At the top of the right-hand column, Lord Justice Longwood deals with Mark Rowlands and Bernie Innes, and then at the bottom of the page, paragraph 77, says this. He then dealt with an argument that contracts should not be construed to exclude negligence unless clear words are used, saying, page 232G, I would not accept this line of argument. An essential feature of insurance against fire is that it covers fires caused by accident as well as by negligence. This was what the plaintiffs agreed to provide in consideration of inter alia, the insurance rent paid by the defendant. The intention of the parties sensibly construed must therefore have been that in the event of damage by fire, whether due to accident or negligence, the landlord's loss was to be recouped from the insurance monies, and that in that event they were to have no further claim against the tenant for damages in negligence. Another way of reaching the same conclusion, on which Mr. Harvey also relied, is that in situations such as the present, the tenant is entitled to say that the landlord has been fully indemnified in the manner envisaged by the provisions of the lease, and that he cannot therefore recover damages from the tenant in addition, so as to provide himself with what in effect be a double indemnity. Although the receipt of insurance monies by an innocent party is of course normally no defence to a wrongdoer, Bradburn and Great Western, Mr. Harvey relied on a number of passages in Parry and Cleaver to show that the considerations of justice, reasonableness and public policy per read may require exceptions to the general principle. I do not think it necessary to elaborate upon this line of argument in the present case, save to say that I accept it and regard it as complementary to the conclusion which is to be derived from the construction and effect of the terms of the lease itself as indicated. And then Lord Justice Longmore continues, thus, even in a case where there was no provision for joint insurance, but the insurance was paid by the guilty party, the insurance was held to cover the liability of that party, and no rights of subrogation existed. Clear words to exclude that possibility were not required once it was evident that the insurance was intended to be for the joint benefit of the parties. So this is, in our submission, the first reason why the conclusion is incorrect. Once the insurance code is evident, clear words to exclude the possibility of rights of subrogation being exercised are not required. If one has regard to the modern approach to interpretation of contracts, this makes perfect sense. there was an insurance code in the Charter. It was the objective intention of the parties seeking consistency and uniformity that the insurance code would be incorporated into the bills of lading. There was therefore no need specifically and expressly to exclude general average.
I'm sorry. No, go on, finish now.
It is, as I've said already, notable that the Gilbert Ash approach was adopted by Mr. Justice Tier and Lord Clark in the Ocean Victory, but not followed. The second reason why the conclusion is incorrect is because it is built, in our submission, on a false premise, namely that the owner's right to seek contribution in general average, which needed to be excluded by express agreement, was a subsisting right. It was not. The insurance code, whilst it does not remove rights of subrogation, is to the effect that there is no right to seek contribution in general average. The intention of the parties was that in the event of damage by insured peril, any loss was to be recouped from the insurance monies, and that in that event the owners would have no further claim against cargo interests. There's therefore no right for the subrogated underwriters to take advantage of. The precise relationship between the assureds takes priority over the broad relationship between insurers, and that's a point that's made by the editors of Carver on bills of lading. And if I can just invite you to turn that up quickly, that's page 1454, paragraph 3068 from the 5th edition of Carver on bills of lading. And in this passage they're dealing with the Court of Appeal decision in this case, and they say the cargo interest defence to the claim for general average contribution was rejected for two reasons. One was based on general commercial practice and the fact that, in a sense, neither party had a financial interest in the outcome since both were insured, and indeed the shipowner's premium had been paid by the charterers. Then they quote from the judgment, after the quotation, as a matter of general principle and practice, this is true, though in another sense it prioritises the broader relationship between insurers and their prima facie balancing of risks over the precise relationship between their assureds, and it is somewhat circular in that the nature of each relationship is dependent on the other, so subject to the terms of the bill of lading contract under investigation. And what they're saying is that in this context, it is the contractual relationship between the bill of lading holder and the owner to which one has to look, and not to the position as between each of those and their insurers.
Sorry, I haven't understood how that bears on the point you were making. I don't see how you, as it were, bypass the Gilbert Ash point, if that's what you're suggesting. At some stage or other of the analysis, there's a prima facie right to a contribution in general average, which you say has been given up.
Yes.
Or contracted out of.
Again, it's part of the iterative process, and I accept that the Gilbert Ash caution needs to be brought to the table, but once the conclusion has been reached that the parties intended to enter into an insurance code, once they've done that, and that the owners will look solely to their insurers, there is no right in general average subsisting.
Well, certainly, but that's the question, isn't it?
Correct. No, I accept that.
And the question at this stage is whether, even if there is a code, it extends to the contribution from cargo owners in general average, or whether it's just as between the charterers and the owners.
The owners, correct.
Is there any advantage to the charterer for them to have contracted this sole fund provision, not only for their own benefit, but also for the benefit of the bills of lading holders? Does it mean they're likely to get more or less money in some way from one of the other parties? I would have thought it was against their interests in the sense that they're liable to pay the premium, or in this case it's capped. But if, as I think we agreed going back, the insurer's premium, other things being equal, will be higher, the more people are protected by this code, then it's contrary to the interests of the charterers for them to agree this for the benefit of the cargo interests, isn't it?
Well, indeed, that argument shows why the party with the real commercial interest is the cargo interests, and that the charterers are, in reality, procuring this arrangement for the cargo interests. And it's because they're on that side of the fence, as we're in the relationship between the owner is the owner of the vessel, the charterer is the person who's purchased that tonnage to carry the cargo from A to B, and the real beneficiary, the likely real beneficiary of the insurance code is going to be the bill of lading holder. Because
well, what money, if any, passes between the bill of lading holder and the charterer then? Or the advantage is that it's the bill of lading holder who pays the freight and discharges thereby the charterer's liability. I'm just wondering what's in it for the charterer to have.
Well, it's because the charterer's interest is in securing the carriage of this cargo on particular terms from A to B, and therefore it's in the charterer is wanting to seek to protect the interests of itself and those for whom it is procuring this tonnage, and therefore they're not looking exclusively to their own very particular interests. They're looking to the commercial purpose of this arrangement, and the commercial purpose of this arrangement is to purchase the tonnage so that it can be used to carry other people's cargo from A to B. And in those circumstances, it's interested in ensuring, insofar as it's interested in procuring this insurance code in relation to going through the high-risk area for all the reasons that are explained in the EVIA, which is that's in the charter context. But in commercial terms, it's doing so for the benefit of those for whom it has procured this tonnage. May I then, if I may, that's issue 2. I was going to then move on to issue 6, if I may. And the question is important to bear in mind. The question page 16. Question 6. Did any such preclusion in the bills of lading extend to claims by the owners for contribution in general average from the bill of lading holders in respect of losses arising out of risks for which additional insurance had been obtained pursuant to the war risks clauses? The question is premised on the existence of a preclusion in the bills of lading. The owners state that there are 2 reasons why even if a code prima facie exists in the Charter or the bills, its ambit does not exclude to claims for contribution in general average by owners against charterers or cargo interests, as the case may be. What the question is aimed at is whether general average is an exception, whether in respect of losses arising out of risks for which additional insurance had been obtained, claims for contribution in general average fall outside of the preclusion. I should say in parentheses that the issue concerns the bills of lading only. The owners have widened the debate to include the Charter in their statement, but that only creates an additional hurdle for them. They have additionally to grapple with the Evier and the Ocean Victory. The next point to note is that issue 6, formulated in this way, was not addressed by the Court of Appeal. The issue addressed by the Court of Appeal is identified page 146 at paragraph 55 in the judgment, and it's the more general question whether the bills of lading excluded liability on the part of bill of lading holders to pay cargo's contribution in general average in the event the vessel encountered a peril insured under any of the insurances. But it was not only the question that was different, it was also the assumptions on which the question proceeded that were different. The Court of Appeal were proceeding, paragraph 44, page 145, on the understanding, on the assumption that there was an implicit understanding in the Charter that the owners were precluded from claiming against the charterers in respect of losses arising out of the risks for which additional insurance had been obtained pursuant to war risk clauses, and paragraph 52 and 54 on page 146 on the basis of its conclusion that the war risk clauses were incorporated into the bills of lading, albeit without manipulation. The Court of Appeal was not making the further assumption that as a result of the incorporation of the war risks clauses into a bill of lading, there was a preclusion in the bills of lading. So as I say, the Court of Appeal didn't address the question raised by this issue. Further, given its prior conclusion that there should be no manipulation of the Charter terms on incorporation into the bills of lading, nor did the Court of Appeal address the issue on the assumption that the war risks clauses were incorporated with manipulation, so as to impose on the bill of lading holders the obligation to pay additional premiums. So that again, they haven't considered that issue. Now, I'm not criticising them for that, I'm just laying the ground, as it were. In our submission, issue 6, as formulated...
So who formulated issue 6?
The parties to this...
I see. Sorry. Right, okay.
It was formulated as part of the statement of issue facts and issue.
Yes, it's in the statement. Yes. Yes.
The issue admits of a simple answer. If there is a preclusion in the bills of lading, then no claim for general average arises, and the question does not arise. On the other hand, if there is no preclusion in the bills of lading, then the question doesn't arise at all. Given that issue 6 assumes a preclusion, the answer must be that claims for general average would not arise. Let me then, just as quickly as I can, address owners' contentions. They make two contentions. The first is owners contend that the preclusion should not be interpreted as extending to claims in general average. To which we say, if the parties had agreed a preclusion of claims against bill of lading holders in respect of losses arising out of the risks for which additional insurance had been obtained, that is their agreement. Turning the owner's argument on its head, clear words would be needed if general average were to be an exception to the parties' agreed preclusion. Let me illustrate by reference to different facts. Assume that before boarding the vessel, the pirates fired a torpedo at the vessel in order to disable her, and that in addition to the payment of ransom, salvors had to be engaged and other general average expenses had to be incurred, and the vessel had to be repaired temporarily to complete the voyage and permanently to repair the damage. It can hardly be suggested that the insurance code would apply to some expenditure but not to other expenditure. Owner's proposition is unsupported by authority, but it can be tested also by reference to authority, again using the Evier as an example. Had the Evier been struck by a missile during a voyage while transiting a high-risk zone covered by Clause 21, but whilst outside the geographical scope of the Safe Port Warranty, there can be no real doubt that the House of Lords would have used the same reasoning to dismiss any claim by the owners for a contribution in general average in respect of the salvage and other expenses and temporary repair costs. The proposition in our submission flies in the face of the obvious commercial purpose of the insurance regime in the context of this particular voyage.
So is your point that if this risk was going to eventuate, then it was going to give rise to expense which was almost always going to be general average? So if you exclude general average from the scope of it, this is not very much left for it to bite on. Is that what you're saying?
No, I'm making a prior point, which is that using the example of the Evier, if the Evier had been struck by a missile, the House of Lords would have adopted and so there would have been
that's the consequence of your submission. If you're right that this insurance code idea must encompass general average, then yes, you would. But the point being made is, no, they wouldn't, because general average is different. If it had been struck by a missile, that would have been something different. But I thought the point you were making was that this insurance is really insurance in respect of what's likely to be loss giving rise to a general average declaration, rather than any other kind of liability.
Well, it could be a total loss, couldn't it? In which case there'd be no question of GA.
correct.
Well, but if it was a total loss, they wouldn't get much ransom for...
I was seeking to give an example on the facts of the Evier, which involved particular average loss being incurred, and in those circumstances, the insurance a torpedo causing damage to the vessel and general average expenditure being incurred for the in order to preserve the cargo and the vessel, so being in the common interest. In those circumstances, I'm just using it as an example to say that it's inconceivable that the House of Lords would not have applied exactly the same reasoning to those different facts as it applied to the facts in the Evier.
But kidnap and ransom insurance covers, I would assume, kidnap and ransom rather than the torpedoing of the vessel.
Correct.
So are there circumstances in which there could be a loss covered by kidnap and ransom insurance which would not be a loss which gives rise to a general average declaration?
I need to think further about that, but my immediate response is no.
Well, I think that helps you then, doesn't
Correct.
it?
Yes, yes. Yeah. And indeed, that's the second contention of the owners, which I'm coming on to deal with now. I think I will touch on similar points. The owner's second contention is that general average should be excluded from the insurance code because cargo interests took out their own insurance. For reasons I've already given, cargo interests insurance in our submission is raised inter alia acta. The cargo interests had their own insurance is neither here nor there. The argument that the war risks insurance taken out by the vessel does not include cover for cargo's contribution to general average is also flawed. It is flawed because it is based on a misconception which has permeated all of owners' submissions. The misconception is that the relevant insured loss is a liability in general average. It's not. The loss covered by... Sorry?
Could you repeat that?
It is not.
No, just
The
before that.
misconception is that the relevant insured loss is a liability in general average.
Yeah.
It is not. The loss covered by the insurance is the ransom which the owner has paid, and the whole ransom. The owners paid the ransom because they were obliged to secure the release of the vessel. The owners' insurers paid the ransom for them, and they paid that ransom because they were liable to indemnify the owners in respect of the whole of the ransom. The peril insured against was ransom, and they were liable for the full extent of that loss. Having indemnified the owner in respect of the loss, the kidnap and ransom and war risks insurers for the amount above 5 million became subrogated to the owner's rights. However, an insurer is only subrogated to such rights of claim as his insured could have brought. At page 1547, McGillivray paragraph 22.103, subrogation barred by the underlying contract. An insurer is only subrogated to such rights of claim as his insured could have brought. Consequently, an attempt to claim reimbursement will fail where the commercial contract between the co-insureds, which is the source of the obligation to insure in joint names, contains terms which expressly or impliedly relieve the intended co-insured defendant from liability to the claimant in whose name the action has been brought. So they're dealing here first with co-insurance. Such liability may be expressly excluded or curtailed. A term requiring joint insurance to be taken out for a number of parties does not automatically mean that no action can be brought by one against another, but is an important factor in the construction of the contract to ascertain how the risk is allocated. And then they refer to the House of Lords decision in cooperative retail, and towards the bottom of the page, even when the intended defendant is not a co-insured, it will be impossible to bring proceedings against him if the contract between the insured and the defendant, that's the commercial contract, is construed to provide that the insurance in question is intended for their joint benefit, so that the insured will look only to the insurers for compensation for loss, whether or not it has been caused by the defendant's negligence. Such intention is, of course, essential and must be derived from the construction of a contract, which is the source of the obligation to insure, such as...
This is all insurance first principles, isn't it? That to which the insurer is subrogated are the rights which the assured has against third parties.
Correct. And if at the commercial level the assured has given up rights, then the insurer is in the same position.
Well, all you can be subrogated to are extant rights.
Correct. In
the hands of the assured.
Correct.
Yes.
And the consequence is that here there are no claims. Once one has come to the conclusion, if one does, that there is an insurance code, there aren't any claims. Any attempt to claim reimbursement for cargo interests will fail because of the commercial contract. The war risks insurance, which the charter is obliged to pay for, did provide the cover in respect of ransom, and the ransom which was paid is the relevant loss. That the cargo interests took out cargo insurance covering cargo interest contribution in general average is also irrelevant. As a result of the agreed insurance regime, it was the intention of the parties that the owners would look only to their insurers for compensation. This is what they agreed, and as a result, the cargo interests never came under a liability to contribute in general average. And for the same reason, on a proper analysis, there was never any double insurance. The cargo underwriters only ever agreed to provide insurance cover in respect of cargo's liability to contribute in general average. If by reason of the contract between cargo and shipowner there was no such liability, then there was no loss covered by the cargo insurance. For completeness, let me deal with the haberdasher's case. That's page 1043. And I need to deal with haberdasher's case just to explain, to show that it was a very different case indeed. In haberdashers, the subcontractor, who was not a co-insured, agreed expressly both to indemnify the contractor against liability in respect of damage to property due to its act or fault, and to insure against liability. So the subcontractor, not a co-insured under the construction policy, agreed both to indemnify the contractor and to insure its own liability. And that is and those two facts, paragraph 70 of the judgment of Mr. Justice Fraser 1060, those two facts were contrary to there being an intention that there would be an insurance fund which would be the sole avenue for making good the relevant loss. It was an express agreement to create a second insurance fund. And for that reason, the decision turned on the particular facts of the case. And I don't think I need to address that further at this stage. If your Lordships and your Ladyship would just bear with me one moment, I want to be certain that there's not a section from the part of my notes which I skipped over that I need to bring to your attention. Oh, sorry. Yes. Sorry, my learned junior points out to me that I'm unsurprising that I hadn't got to deal with the question of manipulation, which I need to deal with quickly in 10 minutes. If manipulation is appropriate, in other words, if you conclude that there should be a manipulation, that is the end to the matter. The appeal must succeed. Neither court below suggested to the contrary, and the issue is whether the requirement on the Charter to pay the premium should, when incorporated in the Bill of Lading contracts, be manipulated so as to impose that obligation on the Bill of Lading holders. Now, we say that that's unnecessary on the true construction of the contract, but if it is necessary, then for the reasons given by the tribunal, that there is no real difficulty with manipulation. So the legal principles are really best set out in the Annafield, and we refer to those in our written statement of case. The degree of manipulation of the words of the incorporated terms of the Charter Party relating to the shipment, carriage and discharge of the cargo or the payment of the freight, that a degree of manipulation is permitted, is established in the authorities, and I don't think that's subject to any challenge. Based on current authority, there is no presumption that the words of the Charter Party are to be manipulated so as to substitute Bill of Lading holder for charterer, but nor is there a presumption to the contrary. In each case, it's a case of construction. The Miramar, again a case of the House of Lords, is authority for the proposition that there is no presumption. There was, in some of the earlier cases, a suggestion that where the terms were germane, then manipulation should be carried out as a matter of general practice. The Miramar sought to stop that as a conclusion based on a presumption. And what one is left with, therefore, is that there is a presumption in neither direction, and one is left with having to decide it as a matter of first principles.
This is if general words of incorporation are used.
Correct. Correct.
But surely the starting point has to be that the words mean what they say, unless there's some reason to give them a different meaning.
Yes. That is absolutely right. But it's the question then is whether there is a reason to give them a different meaning. And one is then driven back to the point that I sought to make at the outset, and that is that the owners in the incorporation of the Charter Party terms into the Bill of Lading were not an empty gesture. They were intended to have an impact, And therefore, if one looks and sees, well, what did the parties intend, that incorporation, what effect did they intend it to have, then one is driven to principles of commercial certainty, consistency, and so forth. And the very reason for short-form bills of lading is in order that there should be such consistency. And in those circumstances, it may not be difficult to decide that a particular reference to charterers needs to be manipulated to bill of lading holders in order to ensure the consistency between the charter party contract and the bill of lading contract. And your Lordship is entirely correct. That is the beginning and end of the analysis. We say that in the light of modern authority, where the widest possible words of incorporation have been used by the parties to a short-form bill of lading contract, that is strong evidence of a clear intention to incorporate the incorporated terms with logical substitutions, and that the parties' objectively reflected intentions should be respected. And again, the points that we make can be stated shortly. It's both possible and legitimate in this case to read charterers to mean lawful bill of lading holders. The learned judge rejected manipulation for two reasons: because of the impact it would have on freight, and because there was no clarity as to how liability was to be shared amongst bill of lading holders. So that's the battleground. The Court of Appeal correctly rejected the judge's first reason, but agreed with his second, and so the obstacle in the way of manipulation in this case is the practical outworking of such manipulation. The Court of Appeal, on the second point, found the reason they found persuasive was that making the bill of lading holders liable for additional premia would be unworkable. It would be unworkable because there is nothing in the bills of lading to say how the liability for premium would be apportioned, or if it is a joint and several liability, what rights of reimbursement the holder of one bill of lading has against holders of the other bills of lading in the event he pays the full premium. And the owners continue to rely upon the unworkable points. In our submission, the Court of Appeal was wrong to give these points decisive weight. In reality, in our submission, on a practical level, the alleged difficulties are more apparent than real. The liability of the holders of bills of lading would likely be joint and several. As a matter of causation, the additional premia had to be incurred to get each parcel of cargo to its destination, and any dispute as to apportionment between them would be resolved by reference to either the value or the volume of the cargo, as it's done in other areas of the law of shipping. Those problems arise in other contexts. They arise but do not prevent the application of general average. They arise when a shipowner exercises a lien over the whole cargo. Indeed, these bills of lading make it clear on their face that holders could face claims for any unpaid freight, demurrage or other charges. Such difficulties are an accepted incidence of carriage under several bills of lading incorporating a single charter party. The scenario discussed by Lord Diplock in the Miramar, where the context was demurrage, was very different for the reasons we've set out in our written case, and I won't go into those. I bet I ought, in the minutes available remaining, deal with the point about the marginal note in the bills of lading, and for that, page 541. This applies to bills of lading 1 to 5 only. Page 541, the marginal note on the right-hand side of the page. The owners contend that no manipulation is possible because it is precluded by the standard form provision that for the purpose of the bill of lading, quoting, charterer means the person entering a charter party contract with the carrier. In our submission, that contention is based on a misunderstanding of the purpose of the standard form provision. The function of the standard form provision is explanatory. It explains who the persons are who are referred to in the boxes on the reverse side of the bill of lading, where one finds the box shipper. The person referred to is the person consigning the cargo for the carriage on charterer's behalf. Where one finds the box charterer, the person being referred to is the person entering a charter party contract with the carrier, and where one finds carrier, the person being referred to is the person equivalent to the ship owner, chartered owner, disponent owner, whichever is used in the charter party to define the person undertaking the carriage. In our submission, the rubric was obviously intended to do no more than that. It was not intended to have any wider application than to what is stated expressly on the bills of lading. But there's one final point. Even if that submission is not correct, the provision does not preclude manipulation. The provision applies to the terms of the bill of lading, post-incorporation and manipulation, and not to pre-incorporation and manipulation. Unless I can assist your lordships and your ladyship further, those are our submissions.
Just one point I'd welcome some help on. I think when you were taking us to that part in the textbook at page 1547 for the proposition that the insurer can only be subrogated to claims which the ship owner has against other people, and the insurer doesn't seem to be able to control whether the charterer gives up those claims. But I think it is a point raised in the Respondents case, or in one of the authorities, that the insurer may say, you failed to disclose to us that in your charter party you had in effect given up your rights and thereby limited our potential subrogation rights, and that was a material non-disclosure, and we are not going to pay out under the insurance policy. Is that a factor that we need to take into account? Doesn't seem to be something that the insurer has raised here, or may have, but we've not been told about that. I'm not asking you. But it does seem to be, if not remarkable, then odd, that the insurer's rights can be cut back so substantially, and yet they're still liable to pay out this $5 million under the policy.
Yes, this is a matter which arises every day in many contexts, take an example of constructors all risks policies, where lots of different people are insured for lots of different interests, and whether or not the insurer has a right of subrogation is dependent upon the commercial contract that is concluded by its assured with third parties. And in those circumstances, it knows that that is a principle that it well knows and understands, and it does lead very often to extensive disclosure being sought of underlying contracts and the like, in order that the insurer can be fully informed as to the precise risk that it's taking on. In this case, one had kidnap and ransom insurers. These are people who came into the market to meet a very specific need. They were, well, I can't give evidence, but they were not asking to see, or if they'd wanted to see what the underlying contractual arrangement was, they could have asked to see it, but they, as insurers, would have known and understood the basic principle of insurance law, that you get no better, your rights of subrogation are only those rights which your assured has against third parties.
Well, the insurer would clearly know that, but I think Lady Rose's point is that there would be an obligation on the assured to point out these terms which were onerous as far as the insurance company was concerned.
In particular circumstances, that may be the case, and it may not, but that's an irrelevant consideration. The law as it stands is that if and that's set out very clearly in McGillivray, and it's not disputed in any context in the insurance world, that you can have no better rights in subrogation than your client has, and if they've given away those rights, that's your problem as the insurer.
To price their insurance accurately, they would have had to look at the documents and then know the answer to this appeal.
Not necessarily. They would have looked at the documents and they would have had in mind the wealth of learning in relation to insurance codes and the risks associated with insurance codes. And if they didn't want to take the risk because they didn't know whether the law was going to decide this case in one favour or another, that's part of the risks that they undertake as insurers.
But the person who loses out in those circumstances would be the ship owner, because they would have paid the ransom to get the ship back, but they would not be able then to claim on their insurance.
Yes, but that, if on that hypothesis, the owner would have been the cause of its own misfortune, because it will have failed to disclose something which it ought to have disclosed, and that's not a reason why the conclusion shouldn't be to the effect that we're arguing. If the owner he might have failed to disclose something completely unrelated, which he ought to have disclosed, but that's on his own head. He's failed to have insurance cover because he's failed to disclose something which he ought to have disclosed.
It probably comes to this, that unless the owner can be satisfied that the insurer knows of the terms, it will be under an obligation to disclose it as a material term at the time of the inception of the insurance.
And one should, for the present purpose, assume that he will have done what he was obliged to do.
Yeah. Mr. Hoffmeyer, thank you very much. Mr. Blackwood, for the...
My lords, my lady.
But Mr. Blackwood, for the comfort of the bench, and perhaps also for counsel, perhaps we can have a 5-minute adjournment and then give you your half hour.
Thank you very much.
Thank you.
My Lords,
Mr. Blackwood, I hope you're fully recovered to good health.
thank you very much, my Lord. Thank you. My Lord, we were going, my Lady, we were going to start with 7 separate issues and address our oral submissions by reference to those topics. The first are some very brief introductory remarks about the meaning of an insurance code and what its purpose is, and picking up on some of the submissions of this morning, how that code arises, whether that code arises solely by reason of construction or whether implication also comes into it. Second, a route map. The issues that arise in the appeal, and more importantly, the order in which we say they should be addressed, which will depend on whether or not the court adopts what we say is the heterodox Route 1 approach, or the orthodox, what we say is the Route 2 approach. Third, the charter. Was there an insurance code in the charter party, which comes into the analysis irrespective of which route is taken, but at a different stage. Fourth, general average. Did the code extend to claims in general average or not, if it existed? And in answer to my Lord Legate's question, the interest of charterers, time charterers, would be in the bunkers on board the vessel. Voyage charterers would be freight at risk. Incorporation, if there was a code, was that code incorporated into the bills effective as between owners and cargo interests without manipulation? And manipulation, which we break down into 2 stages, if the war risk clause, including the Gulf of Aden clause, were incorporated into the bills, should the words "any additional premiums" be for charterer's account be manipulated so as to read the bill of lading holders account? Now, we say within the context of manipulation, that question comes first. And the reason we say it comes first is because we say one manipulates words, not implied terms or implied understandings. And then last, if so, that there is to be manipulation of that obligation, is there an implied insurance code in the bills of lading? So by insurance code, we mean an implied agreement between owners and charterers, or between charterers and bill of lading holders, by which those parties intended to create an insurance fund which was to be the sole avenue for making good 100% of the relevant loss or damage. And the purpose of that code being the avoiding the need to establish breach of the primary liability in contract or tort, and the potential litigation and uncertainty involved in establishing that breach. How is, or what is the implied understanding? We say it is a mixture of construction and implication. Construction: were charterers or any other party obliged to pay additional premium? Was that an express term? Consequence of the express term: is the consequence that charterers are paying premium for no benefit to themselves unless you imply a term that the parties will look to owners' insurers as the sole avenue of recourse? And so we submit that that is the way the process ought to operate. A route map, it's common ground that there's a need for incorporation into the bills if cargo interests take the benefit of it. And then Route 1, or what we say is the heterodox route to determination of the appeal, is simply to ask whether the implied code exists in the charter party, refer to the general, be it broad, words of incorporation by reference, and then posit that bills of lading holders can benefit from that code directed to charterers. And we say that route is impermissible for two reasons. Firstly, it misunderstands the role of incorporation from one type of contract, a charter party, into another type of contract, a bill of lading. And secondly, it fails to properly identify a legal mechanism by which bills of lading holders can take the benefit of a code in favour of charterers. But if that route is the correct route, then the appropriate first logical step is to ask whether there was an insurance code in the charter party. We say that an implied understanding, in the sense which I've described, is not incorporated by general words of incorporation from one genus of contract into another. All that is incorporated are express terms, words, and syntax. There is a literal incorporation or a mechanical transposition of all of the express terms of the charter party into the bill of lading for the purpose of asking the first question, which is whether those express terms govern, or to use the old language, are directly germane to the contract of carriage. So at stage one, all that is incorporated by a mechanical transposition are express terms, not implied understandings or implied terms. Of course, there is no attempt, and has never been, by bill of lading holders to directly rely on the charter party as third parties to that contract. And there could be none for three reasons. The obvious reason is that they're not privy to that contract. But moving on, the charter party itself expressly envisages the creation of a second contract, a bill of lading, to govern rights between bill of lading holders and carriers. So it would be very strange in that context if bill of lading holders could refer to the charter party and rely on it when a separate contract was intended to govern their contract of carriage. And in any event, the war risk clauses do not identify bills of lading holders, either by name or by class, as the intended beneficiaries of any payment. So the Contracts Rights of Third Parties Act could not apply. That would be section 1.3. So the orthodox approach, which we say is the correct one, requires a different step-by-step analysis which proceeds as follows. Firstly, there is a literal transposition of the express clauses of the Charter into the bills, for the purpose of asking whether those clauses govern or are directly germane to the contract of carriage. The next stage is manipulation. But what one is manipulating is words or express terms and not implied agreements or implied terms. And we say that's important because there simply is no way of circumventing, as the appellants seek to do, the question of asking whether or not it is commercially sensible to impose an obligation on bill of lading holders to pay additional war risk premium. That is the first question when one comes to manipulation. And once one has, and only once one has decided that it does make sense to impose a burden on bill of lading holders to manipulate charterers for bill of lading holders to pay the premium, does one have the express words from which then the implied agreement or the implied term, the insurance code, would arise. And we make that submission to emphasise that there is no orthodox route, at least we would say, by which the question of imposing an obligation on bill of lading holders to pay war risk premium is possible. It's a question that must be answered. On either basis, it is necessary for there to have been an implied insurance code in the charter parties for the appellants to succeed. It's the final question, we say, on the orthodox analysis, or the first on what we say is the heterodox analysis. But we identify what we say are a number of guides or indicia which are of assistance when ascertaining whether or not in a charter party an implied insurance code exists. The first, whether the charter party provides that the insurance fund is to be purchased is joint, identifying owners and charterers as co-assureds. If it is, as it was in the Ocean Victory, that is an indication that a complete code was existed by reason of the rule that one co-assured cannot sue another. Second, whether charterers were required by the charter party to procure the relevant insurance or not, as they were in Ocean Victory, but not under this charter party. Because if charterers were procuring the relevant insurance, it could be said to be an indication that they were intended to benefit from it.
You procure it, but the parties to that insurance still be the ship owner and the insurer.
In the ordinary course, it would come together, my lady, with a provision for joint insurance. If the charterers are going to be procuring the insurance, it would be unusual for them to be procuring insurance to which they were not parties, but not impossible. The third consideration, we say, is whether or not the charter parties contained any express provision addressing the payment of insurance proceeds, as they did in Ocean Victory, with insurance proceeds being payable first to the mortgagees, the bank, and then to owners and charterers for their respective rights and interests, which is an indication that both owners and charterers are intended to benefit from a fund. Fourth, and one of the more important indicia, we say, in the context of this appeal, is whether charterers are obliged to pay for or contribute to additional war risk premium in conjunction with assuming additional obligations under the charter party. Now, we say, asking, and my learned friend doesn't run this case, whether an obligation to pay for premium of itself, without looking at the rest of the charter party, in isolation, is not a helpful question to ask. And the reason for that is that an obligation to pay premium of itself is equally consistent with payment for an additional service, which would be otherwise prohibited under the charter party, to which owners wouldn't consent, or it could also be, in other cases, consistent with the creation of an insurance fund. But of itself, payment of premium it is not a firm indication one way or another.
Sorry, could you say that first possibility again, that something would be inconsistent with the terms of the charter party? Sorry, you said that the obligation just to pay the premium...
Yes, could be consistent with one of two things.
Yes, what's the first one?
The first one is simply payment of a service.
Or getting an additional benefit.
You're getting an additional benefit, transit through an otherwise prohibited zone.
Oh, I see.
This charter party, something which owners wouldn't otherwise consent to. So payment for an additional service otherwise prohibited, or constitution of the fund. And the real way of telling the difference between what's intended, payment for a service or an insurance fund, we submit, is whether in conjunction with the obligation to make payment, there is an additional obligation under the charter party on charterers, which obligation incises on the occurrence of the war risk perils. In other words, the charterer, under that hypothesis, would be paying both the premium and paying some additional obligation, for example, hire, or in this charter party, lay time, on the occurrence of war risk perils. The war risk perils are what he is insuring against by paying the premium. But if he had to pay hire, as he did in the AVIA, on the occurrence of war risk perils, then if the service analysis payment for a service were correct, he would be paying for that service twice, once by way of hire and once by way of premium. Viewed another way, the charterer would be getting no benefit for the payment of premium because he was already paying the hire.
I don't quite follow that. Why can't you have a payment made of two components? Consideration that's partly hire, partly premium.
With particular wording, one could. But the position in the AVIA was that there was an additional obligation to pay hire, and there was an additional, and that hire was payable on the occurrence of war risks. It refers expressly to injury or loss of crew. And that there was an obligation to pay all premium, including loss of hire premium. Now, one could have a payment for a service which had two constituent elements, or there could be, as your lordship suggested, if the clause was sufficiently detailed, or it could be said on other facts that the charterer was getting no benefit for the payment of premium.
But what was the additional service that they got either here or in the AVIA?
The additional service here is transit through the Gulf of Aden. That's prohibited unless you have agreement by payment of additional premium to do so.
So it's the possibility of transit through the Gulf of Aden?
No, my lady, we don't say possibility. We say that once it was agreed and freight was calculated by reference to transit through the Suez, that was always intended to be a transit through the Gulf of Aden.
But no contractual right to it. Do you accept Mr. Hoffmeyer's submission? No contractual right.
No, I don't.
You don't?
No, my lord. We say that clause 39 is of no application to the Gulf of Aden clause at all. Certainly when one's considering piracy. One might posit a situation, and I think this was put by my Lord Hamlin, what would be the position if the owner decided in the middle of the Red Sea to go back and go round the Cape? And we would say that unless some change of circumstance had taken place, sufficient to take the matter outside the Gulf of Aden clause, he is obliged to go through the Gulf of Aden. Clause 39 has no role to play because he has already forgone his rights to avail himself of those liberties by agreeing to the Gulf of Aden clause. What was envisaged when the Gulf of Aden clause was agreed to clearly risks of piracy. So what the owner would not be entitled to do is turn round in the Red Sea, go back through the Suez and go round the Cape of Good Hope. He's agreed to go through. He's agreed in the knowledge of the risk that there's a risk of piratical seizure. And he is obliged, as against the backdrop of that risk, to do so. And so we don't agree, and that's probably one of the main points on which we disagree.
So if there'd been some change of circumstances, then they might, but if other things being equal, you say that once the Gulf of Aden clause is there, then they can't rely on the liberties in Clause 39.
Yes, my lady. The Gulf of Aden clause was negotiated against a background of well-known piratical seizure and, of course, political instability in the surrounding countries, Yemen, Eritrea, Djibouti and Somalia, all of which were unstable. So the owner certainly could not rely on the risk of piracy or the existing political instability as a reason to turn round and not go through the Gulf of Aden. There might be extreme circumstances. I suppose, for example, the Gulf of Aden or the exit of the Red Sea into the Gulf became extensively mined because open warfare broke out, perhaps in Yemen. I think it came slightly later, leading to mining. But of course, if there was such a change of circumstance, which was not in contemplation of the parties when they agreed to the Gulf of Aden clause, then the Gulf of Aden clause wouldn't apply at all. And it's also worth pointing out that if the vessel turned round before transiting the Gulf of Aden, which we say it was not entitled to do by reason of piracy or anything else in the parties' contemplation, then the additional premium would never be earned at all. Either if it wasn't paid, it wouldn't be paid because the transit wouldn't take place, would never incept the risks, or if it had been paid, it would have to be paid back by underwriters to owners, and then under the express term of the war risk clause, be refunded by owners to charterers. And so that really is, in short, why we say there is no direct connection, I think as my learned friend put it in his written case, or any interface between Clause 39 and the Gulf of Aden clause at all, on any circumstances.
So it's partly a specific and general point, isn't it?
Yeah.
Yes, sorry, I'd go back. Yes, I'd address the more general point. But going back briefly to my fourth proposition, we say looking at payment of premium in isolation is not helpful. It could be consistent with payment for a service or potentially a code. What one is looking for is an additional obligation on charterers which incises on the inception of a war risk, whereby one analysis would be that the charterer was getting no benefit for the payment of his premium because he was already paying, in the Avia example, higher. Fifth, how comprehensive is the code for the intended voyage said to be? And because, as my learned friend recognises, it can't be said that an implied term or implied code overrides an express code, general average, as it appears under clause 41 of the Charter Party, it said that the implied code only applies for war risks, transit through the Gulf of Aden. And so we say that the consequence of the submission is a rather unlikely one. One would end up with a war risk code that applied to transit through the Gulf of Aden, the Gulf of Aden clause and the Gulf of Aden clause alone, a second code which applied to transit of other war zones, not the Gulf of Aden, and that would depend on the combination of the war risks clause and clause 39, which could have some interplay with the war risk clause outside the Gulf of Aden, because owners had not already agreed to forego their rights to exercise the liberties in those circumstances. But clause 39 has no application to the transit of the Gulf of Aden. Nor do we say that it is indicative of a code said to be a comprehensive 100% sole avenue of recourse when there is a cap to charterers' liability to pay additional premium. It was limited to $40,000 in the aggregate for hull and machinery, crew, protection and indemnity, kidnap and ransom and crew bonuses. And importantly, it did not, as did the provision in the AVIA, make any reference to loss of hire or what would be loss of freight insurance at all. So it was not a contribution which extended to all of the relevant types of insurance. And that is important because it was a feature of the clause in the AVIA. And it was a reason for distinguishing the AVIA by Mr. Justice Bingham in the Concordia Fjord, to which I'll turn. There's no express reference here to loss of hire insurance or loss of freight. But what is said is the words in the Gulf of Aden clause, including but not limited to hull and machinery, kidnapping, ransom. Now we say that would not be sufficient to embrace loss of hire or loss of freight insurance, because by section 55(2)(b) of the Marine Insurance Act, losses proximately caused by delay are not covered under insurance contracts unless the policy provides otherwise. And that was a consideration relied upon by Mr. Justice Bingham in the Concordia Fjord.
Now, would that be a convenient place at which...
I apologise. Absolutely.
Thank you. Thank you very much. We will resume tomorrow morning. Court will now adjourn.